Sorry. So welcome everyone to today's session. My name is Diana Steenkamp. I head up the SDBB marketing department, and we are so excited to be sharing with you today our own personal expertise in the field of family law with Shereen and Robyn and Shirné, and they are really going to be dealing with all those questions that I know everyone has who is currently sitting on this on this webinar. Just in terms of house rules for today's session, we have quite a bit of content to share with you, and I am going to ask that you pop your questions into the chat. We'll deal with it as we can. If there is time, we'll deal with all of them. If not, you can always contact us after the fact and set up an appointment with the department or whatever the case is. Then in terms of certificates for those who have requested it, if you've registered for it, we will be sending you certificates after the fact, and that will be added to your SDBB eVault. And then also notes, etc. We won't be sharing notes specifically of today's session, but like I said, the recording will be made available, and then also obviously the certificates for those who need it. So thank you so much for joining, and then I'm going to hand over to Shereen, who heads up the department in our Cape Town branch.
Morning, Liani, and morning, everybody. Today we are basically going to talk about love and money. Emotional relationships in themselves can be quite messy, as we all know. Two people form a connection with each other, and then at some point that connection becomes a commitment. Sometimes that point of commitment is quite clear. For some people, there's a proposal, there's a marriage, and the relationship is quite defined. People know where they stand. They take decisions about how they're going to get married, and that's a lot less clear-cut when people don't get married. People drift into cohabitation sort of relationships. They don't see it as a financial decision. They usually look at not being married as opposed to being married as something that's about an emotional commitment. And I think what we're trying to convey more than anything else today is that it's a financial decision as much as it is an emotional decision. And it's very important to understand what it means in terms of your rights and obligations in that relationship as the relationship progresses. When people don't get married, there's often a lot of uncertainty about what obligations they have to each other. And because our legal dispensation is also quite uncertain, it can create liabilities that you didn't necessarily sign up for. All of us often have clients coming to us and they want to know about what their obligations and rights may be in a cohabitation situation, because it simply isn't clear cut, and it can also be quite murky once you start to delve into the facts. We know that there are millions of people out there who engage in these relationships. According to the 2016 census, as was reported in a recent judgment, it was 3.2 million people then. We think the reality is that there are far more. People know the term common law spouse and are often surprised to hear that in South Africa we don't have a common law spouse. Cohabitations in South Africa are very different to marriages, and although there's been some legal reform in recent years, these circumstances are limited. We'll get into the detail of recent constitutional cases where, in the case of relationships that end in death, there's been some recognition given to maintenance of surviving spouses and also to intestate succession. But there's less that has been decided by our courts in relation to relationships that are still ongoing. Now, marriages and cohabitations end for only two reasons. They end because the relationship dissolves and the people are still alive, or they end because one or both of the people depart. There's little to no legislation or decisions that assist us when people simply break up in a divorce kind of situation, but they never got married. When you marry someone, you take on a reciprocal obligation to support each other financially. So as the marriage vow goes, for richer, for poorer, in sickness and in health, the idea is if one party is in need, the other party is obliged to help that person. And there's that duty of support. That's why when people get divorced, there's often argument around the question of maintenance. And now I'm not talking about maintenance for children, I'm talking about maintenance for spouses. And that's less clear when it comes to relationships where people have not got married. Shirné is going to deal with recent case law, which lots of people are asking questions about, where the Cape High Court, Western Cape High Court, was asked to deal with the situation where parties hadn't got married, and an application was brought, which is very similar to one which is brought in a marriage kind of situation, a Rule 43 application, which many of you would have heard about, and what the implications of that judgment are. In a partnership, often there's less discussion. As I said to you earlier, marriages often start with a proposal. There's a particular point where the parties discuss their commitment to each other. Cohabitations are different. Often it's a matter of just drifting into a more permanent kind of relationship. And sometimes people are, for various reasons, marriage averse. They avoid the marriage discussion. Or for another reason, they simply don't go down that road. It can be difficult in a cohabitation situation to look back and identify the point at which the relationship became enduring and what each party committed to. So when you get married, you face a decision whether or not you're going to enter into an antenuptial contract. If you don't, then there's law which states that automatically you're married in community of property. So you give up your own separate estate, which you had before you married, and you become part of a joint estate. Each spouse owns an undivided half share, but there's a clear legal structure that defines how the money is going to work in the marriage and how matrimonial property will be shared. If you decide you do want an antenuptial contract, then many people go and get advice as to what the different matrimonial property regimes mean. So at a very early point, you are looking at how matrimonial property or property that falls into the relationship is going to be shared. At that point, you don't really know what's going to happen over the duration of the relationship from a property point of view. One of the partners might stop working or might be in and out of work. There might be inheritances. There might be other things that happen. And an antenuptial contract will define quite clearly what happens with that property during the marriage. So quite apart from the duty of support that I spoke about earlier, where parties have to support each other financially if they're in need, with a marriage, you have this opportunity to get advice and to understand what's going on from a property point of view in your marriage and what's going to happen in the future. You look forward and you plan and you're better advised as to what your rights may be than you are in a cohabitation situation where, as I said, when people drift into a cohabitation and they find themselves now in a relationship that they've been in for a couple of years, Leonie, am I muted? Leonie, can you just...
Sorry, I'm muted. You're not muted.
Okay, thank you very much. Okay. So the point is that married people will ensure that they're satisfied with the basis on which they're getting married. People who are in a cohabitation often don't go through that process of examining their rights and making clear decisions about how they want the property to work in their relationship and how they want the financial relationship to work between the partners. The thing about cohabitation is that there are very few automatic legal consequences. There's a concept called a universal partnership that has been used in our law to be able to give effect to that agreement that people reach to share their property. So the fact that you don't have an antenuptial contract and you're not married doesn't mean that you haven't agreed to share your property in some way or the other, because you may, for instance, have a universal partnership if you've each agreed to contribute money, services, various forms of contribution to a partnership with the aim of creating a profit. And there have been some successful cases where it's been determined that there is a universal partnership between the partners, that they did agree to it when they got together, and they should be sharing the fruits of that relationship when the relationship ends. The thing is, though, that if you want to allege a universal partnership and you want relief through that concept, you have to prove it, and that can be very difficult. So whilst cohabiting parties do have the option of concluding an agreement and setting out their rights and obligations in that agreement, and we deal with those matters all the time, it's a lot easier if you have a written agreement where everything is defined to be able to go to a court, or better still, not have to go to a court, because the legal situation is quite clear from that contract with regard to, firstly, whether or not you did take on a duty to support each other, and secondly, whether or not you agreed that the property that you built up during the marriage will be shared between the two of you, sorry, not during the marriage, during the relationship, will be shared between the two of you when that relationship ends. There doesn't have to be an agreement. One can, a written agreement, one can prove if one has a good indication, and it's quite clear from the way in which people behaved themselves, how they conducted themselves, that there might be emails, there might be letters, there might be other things that happened in the course of that relationship that make it quite clear that the parties did commit to a universal partnership kind of contract with each other, or, for instance, that one of the spouses agreed that they would support the other spouse. That happens sometimes when you have a long relationship between two people and one of them stops working because they're going to raise children, and there's quite a lot of discussion between the two of them as to whether they're married or not, that the person who is working is going to support the person who's not working. And sometimes by the conduct of the two partners in the relationship, you can prove and show that there was a duty to support. Of course, unlike a marriage where that duty to support is automatic, it's not clear-cut, and it much will depend on the circumstances of each case, and it's not possible to make anything other than generalized statements that there could be a duty, because you'd have to look to the facts and circumstances of each case. Very few people do, however, think about having cohabitation agreements, go and see lawyers and get advice about cohabitation agreements, because I think most people look at it as an emotional decision as opposed to a financial decision, as I said at the outset. Sometimes the question arises when people purchase property together. So being part of a firm which has a strong property arm, it does often happen that through the property transactions that our firm is involved in. Sorry, Leonie, I just want to pause and check. Our screen is not looking great. Can you see and hear me clearly?
I can hear you clearly. I think it's just, okay. There we go. I think it's just that's fine.
Okay. So often when people are about to become co-owners of property, it triggers a desire to put a cohabitation agreement in place. I think people should be thinking about it long before then, but that is a good moment to stop and pause and consider when you're going into buying property together. Even if two people don't feel they're emotionally ready to tie the knot, that's an important time to stop and look at what the basis of the cohabitation is and how the property is going to be shared. That is a good trigger and a good time to put it front and center. The other reason why many people sit down and for the first time properly consider their rights and obligations as a cohabiting couple is when they have children. And Robyn is going to take you through the law relating to parental rights, because this is an area where there's been quite a lot of legal intervention. The Children's Act put an unmarried father into a far better position than he had been historically. And as Robyn will explain, There's still an element of automatic legal rights if you're a married father, but the gap has largely been narrowed, and the position as between married and unmarried parents is very similar. Before I hand over to Robyn, I just want to make it clear that in the questions that we take, we're going to focus on the areas that we're discussing. There are obviously other legal problems that cohabiting couples will experience, but we're going to focus on distribution of property in cohabitation type relationships, cohabitation agreements, maintenance obligations that may arise, and the rights relating to children. So on that note, Robyn's going to explain in further detail the position relating to parenting rights.
Great, thank you, Shereen. All right, so first let's start with looking at parental responsibilities and rights and who acquires those rights. So as Shereen mentioned, the biological mother of a child, whether she is married or unmarried, naturally by virtue of giving birth to the child, she acquires full rights. Then Section 21 of the Children's Act speaks to the rights of unmarried fathers. And I think for the purposes of these discussions, Section 21 says that a father acquires full parental rights and responsibilities if at the time the child is born, he's living with the mother in a permanent life partnership. So for the purposes of these discussions, we can assume that both parents do have parental rights and responsibilities. And let's take a closer look at what those rights and responsibilities entail. Section 18 of the Children's Act sets out the rights, and first and foremost, it's the right to care for the child. This includes providing a suitable place for the child to live, safeguarding their well-being, and protecting them. Then the second one is to maintain contact with the child. That speaks to maintaining a relationship with the child and communicating with them, visiting them, etc. Then the third right is being entitled to act as a guardian for that child. So making decisions for them, managing their assets, and that. And then fourth and not least is the right to contribute towards the maintenance of a child, which speaks to the financial aspect. Now that we understand that who is entitled to these rights and what the rights are, let's look at how these rights can be enforced fairly. So naturally, when parties get divorced, these aspects are dealt with as part of the divorce process. Of course, when we speak to life partnerships, there is no divorce process. So we need to look at how we ensure these rights are fairly exercised when parties decide to go their separate ways. The simple answer, and it sounds much more simpler than it is, but in essence, we need to get a parenting plan in place. The parenting plan will regulate where the child resides primarily and how the non-primary parent can exercise contact with the child. Much like any agreement, ideally, the parents should come together and be able to agree on all the aspects, which can then be made in order of court. Sometimes the assistance of a mediator can be incorporated, so the parents go to mediation and they reach agreement that way. Once the arrangements are reduced to writing, it's made in order of court and it's more easily enforceable. In circumstances where parties are unable to agree, that one of the parents has to make application to the children's court or the high court. Practically, it's more cost effective to approach the children's court. The children's court will then be tasked with the responsibility of appointing a social worker. That social worker will have to conduct an investigation, speak to both parents, speak to the child, and then provide the court with recommendations. The court will then look at all the circumstances of the case and, in essence, make an order on how the parent should exercise their rights. Of course, the courts naturally try and encourage parties to reach an agreement because this is an arrangement that's going to have to be enforced for a long time. And the court always tries to consider what's in the child's best interest, which is usually that the parents can agree on an arrangement. One of the other rights that have to be quite strongly regulated or enforced is the right and duty to maintain a child. So again, who has the responsibility of maintaining a child? It would be their parents. While the parents are living together, everything usually goes well. One parent will contribute in one way and the other will contribute in another way. And then when the parents decide to go their separate ways, suddenly they both dig in their heels and they fight about who's responsible for what. And so it's important to look at Section 15 of the Maintenance Act, which provides for what constitutes maintenance. The parents are responsible for providing for proper living for their child, which includes the provision of food, clothing, accommodation, medical care, and education. We would then look at how it's determined who contributes to what, and when determining the amount, parents obviously both have a joint responsibility, and one would look at the parents' respective means. Their obligation is apportioned between them according to their respective means. So again, parents can come together and decide who's going to contribute what. The correct application is that it needs to be apportioned pro rata in accordance with their means. The parents can sit together and decide who's going to pay for what. Alternatively, one of the parents would have to bring an application to the maintenance court, and the maintenance court again would look at both parties' financial means. They'll require a lot of paperwork from both sides, and they'll then look what's in the best interest of the minor child and make an order, which is then enforced on the parties.
Robyn, and quite importantly, I think for anyone going through a split who's a cohabiting couple, it would be important to know that all these remedies are available to you whether or not you're married. Yes. And that's it's not confined to people who are married. The law will treat you in exactly the same way whether you're married or you're not married.
Absolutely. So yes, by virtue of the fact that you're both entitled to parental responsibilities and rights, you come to the court and you will be on equal footing when making application. Either the mother or the father can bring these applications, and often after the termination or the dissolution of the relationship, sometimes there's no fighting and things just continue without any sort of conflict. But we always recommend putting an agreement in place in any case and having it made an order of court, because you never know what's going to happen down the line. If one person suddenly enters into a relationship with someone else, sometimes there can be jealousy and fighting. And so from the onset, we recommend getting an agreement in place, having it made an order of court, and then further down the line, you can always enforce it.
Absolutely. It's the same reason why people enter into antenuptial contracts and why people should enter into cohabitation agreements. The clearer your rights and obligations are at the outset when things are good, the better you can resolve conflict when things are not so good.
That's all from me for now.
Thanks, Robyn. I'm going to hand over to Shirné, who's going to take you through some of the recent case law. Over to you.
Okay, so I'm going to look at maintenance between the parties. So Robyn dealt with maintenance applications in the event of the parties having minor children and how to approach the court. So as Shereen mentioned, our law currently provides very little automatic protection for partners in a permanent life partnership. Currently, there's no automatic duty of support arising by operation of law. There has been some recent judgments that have tried to address the issue. The first important one is the Constitutional Court judgment of Bonya versus Master of the High Court. So the judgment was handed down on 31 December 2021, and STBB represented the applicant in that matter. So firstly, the court was to determine two questions. The one being whether a surviving partner of a permanent life partnership is entitled to claim maintenance in terms of the Maintenance of Surviving Spouse Act. So the Act provides that on termination of a marriage by the death of one of the spouses, the surviving spouse can claim from the estate of the deceased spouse maintenance in as far as that surviving spouse is unable to provide for his own expenses. The Act does not provide for partners in a permanent life partnership. In this matter, according to the Constitutional Court, the applicant's relationship with the deceased comprised of most, if not all, of the elements of a marriage. The parties were engaged to be married. They discussed cementing their relationship with the baby, and they've planned a trip to Zimbabwe for them to negotiate and pay lobola to the applicant's family. 2 months prior to the intended trip to Zimbabwe, the applicant's partner passed away. The applicant instituted 2 claims against the estate. Firstly, a claim for maintenance, and secondly, a claim to inherit in terms of our Interstate Succession Act. Both claims against the estate were rejected by the executor as they were not provided for in terms of legislation. That's when the applicant turned to the High Court and thereafter to the Constitutional Court. The Constitutional Court came to the conclusion that the protection afforded to spouses in terms of the Maintenance of Surviving Spouse Act must be extended to people, a partner in a permanent life partnership. The court then suspended the operation of the order for an 18-month period to allow Parliament to address the issue. This means that there is now scope for a partner in a permanent life partnership to claim maintenance from the deceased partner's estate. The second question that the Constitutional Court had to decide on is whether or not the surviving partner can inherit in terms of the Interstate Succession Act, which was previously not permitted. The court found again that the surviving partner should be entitled to inherit in terms of the Interstate Succession Act, and that order was also suspended for an 18-month period. So the 18-month period will be over on 1 July this year. Then a more recent judgment is EW versus FH, which was a Cape Town High Court judgment handed down 17 March this year. In this matter, the application was launched for developing the common law to provide for a maintenance obligation in a cohabitation or permanent life partnership agreement. Secondly, the applicant asked the court to grant interim maintenance order pending the outcome of the main action. So the main action was an action instituted for maintenance after the dissolution of the life partnership and to develop the common law. So the main action is still pending in High Court at the moment.
And Shirné, can I
Yes, absolutely.
chop in there and just say that for anyone, just to contextualize it with what I was saying earlier, it's a case where 2 people were involved in a partnership for a long time. They had 3 children together. They never did get married, although if I recall, they had some kind of ceremony. They had a commitment ceremony. They went and they had 3 children. They spent a long time together. And so it's one of those cases, like I was explaining earlier, where by the parties' actions and through things that they did and how they treated each other in the marriage, the partner in the relationship who is alleging that she's entitled to maintenance is saying that there was really an agreement between the 2 of them when they got together and in terms of how they were during the marriage, during the relationship, that he agreed to maintain her and should therefore maintain her after the relationship ended.
Yeah, so that's the main action that's still pending. Then in terms of the judgment, it was an application for interim maintenance, as in up until the point where the court makes an order on the final action instituted, as Shereen described, the respondent has to maintain the applicant. That's similar to a Rule 43 application that you would bring in a setup of a divorce that Shereen also touched on earlier. So the court found that they were not in a position to make an informed decision on the application about whether or not the common law should be extended. And on that basis, the application for interim maintenance was dismissed. So the practicality of that is that the legal position surrounding maintenance in the event of a life partnership terminating, not by way of death of one of the partners, still remains unchanged. There's no duty of support in terms of a life partnership by operation of law. In order to be successful with the claim for maintenance, the partner will have to approach the court and then prove the existence of a life partnership, which included the duty of support. So this is more like a contractual relationship where you have to show that. That's where Shereen also mentioned, they'll look at the conduct of the parties, whether there were emails, letters, the intention of the parties, etc. So you have to prove a partnership, that partnership included the right to maintain each other, and then based on that, you can claim maintenance. So that is the reason why it's still advisable to have a written agreement in place in the event of a permanent life partnership, because there is no automatic legal protection afforded to parties in the event of a breakup.
So that's our current state of the law. We obviously waiting with bated breath to see what comes out of Parliament and what happens, particularly given the decision in the Bonnier case and the fact that, what was the date that you mentioned, Shirné?
1st of July.
1st of July, by which legislation must be passed. Now, there have been previous attempts to make legislation. There have been draft bills, there have been law commission inquiries, and there's been much discussion about creating legislation that makes the position of partners more certain. But we still don't know where this will go and exactly how a partnership will be defined, or exactly what protections will be extended to partners. Sorry, I'm just trying to read the question because we're now in a position to take questions. Leonie, can you tell us what questions people have?
So
answer.
Okay, so the first question that we have is a scenario that Craig has put forward. A retiree is considering cohabiting with a partner, but it's imperative to protect one's asset in the unlikely event of the relationship ending. In order to achieve this, would it be safer to get married, whether ANC or without accrual, or simply cohabit? Or would it be advisable to arrange a cohabiting contract similar to the antenuptial without accrual? So I think that's a bit more of a type of scenario that Craig has put forward.
Okay. All right. Well, look, I think I obviously need to make clear that we're not going to give specific legal advice in the webinar, but we can talk generally around the legal principles. And it's an interesting problem that's raised because at the moment there is a case pending before the Constitutional Court about marriages out of community of property, which creates quite a lot of uncertainty in those marriages as well. Clearly, the family law is a reflection of society and how relationships are happening in society, and there is a lot of change. It is very fluid, so we can see that in the legal position and the fact that the case law is as it is. It's also interesting that we're seeing more and more relationships both terminating, amongst the older part of our population. It used to be that there were more divorces in amongst younger people, and now we're seeing more and more that older people are deciding that even though they might have previously thought they'd committed for life and must just hang in there no matter what, there seems to be more of a sense that you must get out there and terminate relationships if they're really not working for you, even if you've been together for 30 years or so. I think that when people get together as older people, it is particularly important to protect your property. I mean, we see with marriages of older people also that it becomes very problematic when you've got a pension or you've safeguarded your assets in such a way that you're planning for the future, and suddenly there's a divorce, and what you thought was your retirement nest egg is now half or a proportion of what it was. Getting married out of community of property used to give you security, because South Africa was one of the one countries in the world where an ANC was absolutely given effect to. But prior to the introduction of the accrual system, there was law that allowed for courts to redistribute assets, because pre-1984, you could only really get married out of community of property or not have an ANC and be married in community of property. You didn't have the option of the accrual system, which gives you a lot more flexibility. What a recent case has done is it's removed that time bar that post 1984, you couldn't bring in redistribution. Now you can look at it in out of community of property marriages according to a high court decision. That decision still has to go to our constitutional court. So it's not binding as yet. It may become binding depending on what the constitutional court says. And as we saw in Boana, often what a court will do is say this, it'll make a finding, what the constitutional court will do is make a finding that something is not constitutional, but then we'll refer it back for the legislation to change, and then there's a time period for that legislation to change. So quite a long answer, but I think that one would need to look at the facts and circumstances for each party, and I think in all probability a cohabitation agreement which is particularly tailored to their facts and circumstances is the best idea. But in that scenario, it's important to get specific advice. There isn't a general position that applies.
Leonie, if I can, I saw one of the questions pop up at the bottom where it was asked whether there is an automatic right to claim maintenance or claim in terms of the Interstate Succession Act, given this judgment. So just to clarify practically how it will work. In a marriage setup, if the marriage is terminated by way of death of one of the spouses, the surviving spouse has a claim in terms of the act, the Maintenance of Surviving Spouse Act. The Act only provides that the surviving spouse can claim maintenance in as far as he or she is not able to maintain himself. So they have to look at your earnings and your means, etc. So practically how that would work is you need to submit a claim to the executor, setting out why you are entitled to maintenance, why you can't maintain yourself, and then quantify your claim. So what the judgment has done is they've extended that protection to partners in a permanent life partnership. So to get maintenance, it's not an automatic in as far as if you are currently in a relationship, a permanent life partnership, your partner passes away, you will get maintenance. That's not the automatic protection. The automatic protection is now that you are entitled to apply for maintenance or submit a claim for maintenance if you meet the requirements. So you would still need to, firstly, now you need to set out why you believe your relationship was, in fact, a permanent life partnership. This is where you look at the facts of a particular matter. In this judgment, as I mentioned, they were engaged to be married, they were discussing having a baby, and they were planning to travel to Zimbabwe to pay lobola. So you have to set out the facts why your relationship should be considered a permanent life partnership. Then you need to still quantify your maintenance claim and set out to what extent you can maintain yourself or not. The executor will then be tasked with considering the claim, and if they are of the opinion that you have proven all the elements, they will approve your claim. They can either then dispute your claim if they don't agree, or they can reject it outright, in which case you'll have to approach the court.
Yes, and maybe I want to just go a little bit further back, and at the risk of oversimplifying things, just to be clear that when we talk about a reciprocal duty of support or duty to maintain, that's purely in the event that you have somebody who's in a situation of need. So as Shirné said, nobody automatically gets maintenance. So whether you're married or you're not married, the issue of the protections is for somebody who needs it. So if you're married and you need maintenance, because for instance, your spouse dies and they don't leave you anything and you don't have any assets of your own and you need maintenance, you can claim under the Maintenance of Surviving Spouses Act, but you need to be in a situation of need. And as has now been determined in Boana, that protection is extended, but again, will only be available to someone who is in a position of need.
Yeah, I think like that clarifies it from my end, or the question. The other question that I see that has also been posted, and I think that, just a bit of clarity on that is, the question is regarding cohabitation and whether a cohabitation agreement is necessary to be made in order of court, or it's not necessary to go to this extent with an ANC. Is an alternative option to register the agreement in the deeds office. So I think there's a bit of confusion regarding when a cohab agreement is necessary versus an ANC, etc., and just how procedurally you would go about getting the right document in place for the right circumstance.
Okay, so Shirné will deal with the deeds office. I first just want to say that the question of whether something is made in order of court, obviously it's up to the parties. If you come to an agreement, you can apply to court for it to be made in order of court. The question of whether an agreement must be made in order is always a question of enforcement. So often with cohabiting parties, if they have children, then it would make sense to have a parenting plan, as Robyn explained, and it might make sense to make that an order of court because it incorporates both regulating rights relating to children and rights around property and money. And a court order will always be stronger protection than an agreement, especially if people start disputing the points of the agreement later. And that's, again, a personal choice that people need to make, and one on which they should obtain advice. You can speak about the registration of ANCs.
So an antenuptial contract has to be registered at the deeds office, and that's in terms of legislation, it's a requirement. So an antenuptial contract has to be signed prior to a marriage and registered within 3 months from date of signature, and registration is at the deeds office. A cohabitation agreement or partnership agreement is not registered at the deeds office. So if you want to have more protection than just the agreement, that is when you, like Shereen said, approach the court to have it made in order of court. But there is no option of registering a life partnership or cohabitation agreement at the deeds office.
At this stage, maybe that's something that the new legislation will address. I think it's likely that legislation will provide for, if people want to make an agreement, then there will be some kind of registration process to do that, because that's one of the things that can create more certainty. And if it's made easier and possible to do that, like it is with ANCs, then obviously that's preferable.
Okay, so I think that clarifies that point. The next question that we have is to outline a typical format of a cohabitation agreement and what are the essentials.
It would depend very much on whether or not people are co-owning property, because the co-ownership elements usually go into quite a lot of detail in most co-ownership agreements, but it ranges from regulating who pays for what in the household and how it's shared to what happens with all your assets. In each case, it's different. I mean, if they're pension funds, you would propose that people think about how they're saving for their pensions. I mean, a lot of people have an automatic pension deduction that's part of their salary. So you'll look at the two parties in the relationship, and you'll have to consider their whole financial life and how those relate to each other. So you look at things like inheritances and what happens to inherited assets. You'd look, as I said, at pensions and people's pension savings. You might find that one person, by virtue of their employment, has a pension deduction. So they have quite a big percentage of their salary that's being hived off as a pension saving, and the other person doesn't have any pension savings. If they have children, you'd look at who's paying for what. What very often happens in South African domestic relationships is that the person who has the job is the person whose house the name the house is registered in, because they have a salary slip which they can use to apply for a bond. And so sometimes houses are registered in one person's name, and on the face of it belong to that person, and the other person will pay for groceries and things for children and electricity and the like. And so cohabitation agreements will look at those household budgets and will address how the person who is contributing towards the asset is going to share that asset with the other person who's contributing towards other things.
If I can add there, what I've had quite often is where parties don't want to get married. They want to enter into a permanent life partnership, have a cohabitation agreement, but they want something similar to the accrual system to be implemented. So then in the agreement, we will structure some form of either asset sharing or some form of payment based on the value of the assets at time of termination of the relationship. So you will build in something similar to the accrual, but you will build that into a cohabitation agreement.
I think that speaks to the other question that we have regarding that automatic right of maintenance, and the fact that does a cohabitation agreement then make it easier to get maintenance? So yeah, maybe you can just respond to that.
It makes a massive difference, because you can create that same duty of reciprocal support that exists automatically on marriage. If you have a cohabitation agreement in which you state very clearly that we agree to a reciprocal duty of support, then you put yourself on the same footing.
And then also
almost the same footing, because to actually enforce that agreement, you have to go to court. But then, if you don't have agreement in a divorce around what that duty of support looks like on the termination of the relationship, you're also faced in a situation where you have to go to court. So it's a very similar footing.
Okay, I think then also a question from Marnie is whether all of this then applies to same-sex relationships.
Yes, absolutely. Without any difference between same-sex and opposite-sex relationships.
Okay, I think then I don't know, was there any other question? Gugu, there was quite a long scenario from Gugu, but I think Gugu, maybe it would be best to set up an appointment with one of our professionals to address your scenario. Is there any other questions, I think, before we end off? Okay, so let's just see the...
Yes, may I ask something?
Yes, please.
If an older couple have an agreement, they live together and he contributes towards the monthly towards the living costs, they do sleep in separate bedrooms, so he's basically a boarder. What if he decides to, if she decides to split up with him and he decides, no, he's been living with her for 3 years, although it's separate bedrooms, does he have a claim on her property?
Well, at the moment, there's no automatic claim in relation to property. There's no legislation that would create a claim. So one has distinguished. I think you're asking about a proprietary claim and not a maintenance claim. So firstly, to be clear about that, are you limiting your question to the proprietary aspect? Maybe I could just go on to say that in every relationship, you'd have to look at the facts and circumstances. So you use the words, he's just a boarder, but the question is, what was the nature of the relationship? So it might have been a relationship which started in a certain way and then kind of petered out and became something else. So one would really have to look at the nature of that relationship. But it seems very unlikely in those circumstances that there would be a claim, but one would obviously need to hear more.
Okay, then there's quite a few more questions, so we'll see what we get to. I think we'll take about 2 or 3 more questions and then we'll end off. So you have a right to claim maintenance from a deceased life partner even without a cohabitation agreement.
Yes. In the event that you can meet the requirements. So that is where you have to, if you submit your claim, you have to show that your relationship was in fact a permanent life partnership. you need to quantify your maintenance claim, and you need to set out the need for maintenance. So whether or not you can maintain yourself or to what extent with your available needs. So it's not an automatic, if you are in a partnership, you get maintenance, but you can certainly put in a claim if you meet the requirements.
And I think it's important to understand that a lot of these claims before this case were simply rejected by executors. And the importance of the case is that it says that it's not constitutional to treat people differently. You can't say that simply because somebody got married, they should, they have a claim. You've got to be able to give people who in a permanent life partnership the opportunity to make the claim. But the legislation is going to make clearer exactly what that relationship has to look like and what requirements you have to fulfill for it to be recognized as a permanent life partnership.
Okay, I think that ends off. There's quite a few other questions, but I think we've run out of time. So I'm going to share my screen so that you can just also see the details there for Shireen. Let me just stop this, sorry. So you should be able to see the screen just in terms of the contact details for Shireen and Shirné and Robyn. So it's familylaw@stbb.co.za. You're more than welcome to set up an appointment with them and to, so they can assist you with regards to any disputes or cohabitation agreements that you need drafted, etc. Thank you so much for joining us, everyone. I think that concludes our session. Again, there were here, I see that some people aren't seeing my screen. Let me just reshare. Sorry.
We can't see it on our side.
Yes, it seems like mine's giving an error. So no, it doesn't. I don't know why it's not allowing me to share for some weird reason. Anyway, we'll send out the contact details, but it is familylaw@stbb.co.za. And you are more than welcome then to contact us after this. After the session, we will be sending attendance certificates for those who registered. We will be making the recording available for a limited time, and then the contact details. So thank you so much for sharing with us and joining us today and asking the relevant questions. I hope you've found this very helpful, and be sure to look out for our future events where we will also be sharing these type of webinars that can help and assist you with future arrangements. Thank you so much, everyone.
Thanks, everyone.
Thanks, ladies. That was really very informative. Much appreciated.
Thank you. Thank you for the feedback.
Righto, bye.